Hi, my name is Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called Service of the Police Brief, and it's designed to assist legal practitioners in the Local Court of New South Wales. Section 183 of the Criminal Procedure Act requires the police to serve their brief of evidence at least 14 days before the hearing, and that is so that the accused person has an opportunity to see the case against them and to prepare their defence. Now, Section 188 of the Criminal Procedure Act says that if that brief of evidence is not served, or if some part of the evidence isn't served, then that evidence is not admissible in the proceedings. And so, although the service requirements may not be the most glamorous part of the law, and some people would say they're actually very boring, in fact, they are an essential tool that every defence lawyer needs to know, because if some evidence hasn't been served, you need to know how to respond to that situation. So if the police have not served a brief of evidence 14 days before the hearing, then that evidence is not admissible, and that is usually fatal to the police case. So what normally happens in that circumstance is the police will make an application under Section 187 of the Criminal Procedure Act and ask the court to waive those service requirements. And then the court can do that, but only in two circumstances. The court has to consider the interests of justice and make a finding of fact that there are either compelling reasons why service shouldn't be required, or that it was not reasonably practical for the police to serve the evidence. And that finding of fact has to be based on evidence, so the informant would be required to get in the witness box and give evidence as to what attempts he's made to serve the evidence and what are his compelling reasons for not being able to do so. After that evidence is taken, you would then make your submission and say, first of all, that the police carry the burden of showing compelling reasons. Secondly, that whatever reasons they've offered are not compelling. Thirdly, that the defendant is prejudiced because he hasn't had the opportunity to prepare his or her defence. And lastly, that the interests of justice weigh against dispensing with the service requirements. If the court declines to dispense with the service requirements, then the police will seek to adjourn the matter so that they can comply. And you will make the submission that the police have commenced the proceedings, that they were aware both of the date and their obligations to serve a brief, and that they failed to provide compelling reasons as to why they did not. In those circumstances, you oppose an adjournment. However, if one is to be granted, then you would seek a cost order under Section 216 of the Criminal Procedure Act, because if your client is required to come to court on another day, clearly that is prejudicial to him, and even if he is funded by legal aid, he still has to pay the $75 co-contribution.